You're in a courtroom, you expect to hear a witness's story once, right? But what if the jury could hear a victim's story twice? First, from the victim on the stand, and then again from a friend they told right after it happened. Well, there's a really controversial rule that allows for exactly that, and we're going to break down how it works and, more importantly, why.
So let's just dive right in with a legal puzzle that gets to the absolute heart of this. A sexual assault trial is happening. The victim gives their testimony. Then the prosecutor calls the victim's friend to the stand, and that friend tells the jury the exact same story the victim told them just moments after the incident. Now, should the jury be allowed to hear that second telling of the story? Is that even fair?
The answer, believe it or not, is super complex. And to really get why this is allowed in a modern courtroom, we've got to go way back. We have to look at the rule's ancient roots, which started out as something completely different.
Okay, so originally, under ancient law, a woman who'd been assaulted had to make a hue and cry, a literal immediate public outcry to prove she didn't consent. As the courts evolved, so did this idea. For a long, long time, a witness could only get up and say, yes, a complaint was made. That's it, no details. But then came the Hawkins ruling, and a judge basically said, you know what, just knowing a complaint was made isn't really enough. The court needed to hear the full story. But, and this is key, for a very, very specific reason. And here it is, the crucial line from that ruling. The whole point of hearing the story again was not to prove the assault actually happened. Nope. It was to show the consistency of the conduct. In other words, does the story the victim told their friend right after the incident, does it match the story they're telling now in court? It's all about consistency. That single idea is the bedrock of the entire modern rule. So fast forward to today. How does this actually play out in a trial? It's not a free-for-all, I can tell you that. For someone else to be able to repeat a victim's story, the modern complaint rule has some really strict conditions that have to be met. For a complaint to even get in the door, it has to clear 3 hurdles. First, this rule only applies in criminal cases for a sexual offense. Second, the complaint has to have been voluntary. And third, it has to be speedy, meaning it was made at the first reasonable chance the person had. Now, let's zoom in on those last 2, because that's where the nuance really kicks in. So what does voluntary actually mean? Well, a lot of the time it comes down to the kind of question that was asked. A really general open-ended question like, what's wrong? Or why are you crying? That's usually fine. It just opens the door for the story to be told. But a leading question, something like, did John Doe assault you? That crosses a line. That's not seen as voluntary. That's seen as suggesting the answer. And what about being speedy? This isn't about pulling out a stopwatch. The law actually gets the human side of this. The court looks at the real-life circumstances, things like the victim's age, the trauma they've been through, and their relationship to the person they're accusing. A young person abused by someone they trust, for instance, they might take a lot longer to feel safe enough to say something. And the law gets that. Okay, this brings us to the most crucial and honestly the most misunderstood part of the complaint rule. If you get this next point, you get the entire thing. This is the aha moment. It's all about the very specific and very limited reason this evidence is even allowed. Here's the absolute core of it. The judge tells the jury, in no uncertain terms, that they cannot use the friend's story as proof that the assault happened. It is not evidence of the facts. What it is evidence of is the victim's consistency. It just helps the jury decide, is the story this person is telling today in court consistent with the one they told right after? It's all about whether they seem like a credible witness. That's it. And this distinction is why the complaint rule isn't technically an exception to the big, scary rule against hearsay. Hearsay is when you use an out-of-court statement to prove that the statement is true. But remember, here, the complaint is only being used to show consistency, not truth. So it does this kind of neat legal sidestep around the entire hearsay rule. Pretty clever, huh? Let me try an analogy. Think of it like a receipt. A receipt doesn't prove that the sweater you bought was good quality or that you even like it, but it does prove that you bought a sweater on that day at that store. It makes your story about buying a sweater consistent and more believable. That's exactly how the complaint rule works in court. But, and this is a huge but, just because there's a neat legal logic to it doesn't mean everyone thinks it's a good idea. Far from it. The complaint rule is actually one of the most criticized rules in all of evidence law, with a lot of people arguing it's just plain unfair and outdated. And you don't have to take my word for it. Listen to this zinger from the legendary American judge Oliver Wendell Holmes Jr. He called the rule a perverted survival of the ancient requirement that a woman should make hue and cry. Wow.
He basically saw it as a twisted relic from a time when a woman's word simply wasn't trusted on its own.
And the criticisms just keep coming. Critics say, look, it's illogical. How can you support testimony with something that isn't even evidence of the facts? They say it's incredibly prejudicial. You're asking a jury to listen to what could be a really graphic story and then just pretend they didn't hear it as fact? Come on. It's also seen as weirdly random, applying to some crimes but not others, and, let's be honest, almost always helping the prosecution.
So, after all that, a journey from ancient law all the way to modern courtroom debates, what's the big takeaway here? What should we walk away with?
At the end of the day, the complaint rule forces us to stare down this fundamental question. Is it a necessary tool to help a jury judge credibility in some of the hardest cases imaginable? Or is it a flawed, prejudicial relic that asks jurors to do a mental trick that's basically impossible and, in doing so, unfairly tips the scales of justice? As you can see, the debate is fierce, and it is far from over. Thanks for digging into it with us.